Hello. So this is different streamer. హలో అది లైవ్ రావట్లేదు అది మళ్ళీ క్రియేట్ చేస్తున్నాను అది So I'm starting this program now. So I'm starting the questions. Who among the following Chief Election Commissioners of India have also served as the first Chief Election Commissioner of Nepal and Sudan? So it was Sukumar Sen was the first Chief Election Commissioner of India, as well as was the first Chief Election Commissioner of both the countries in 1953 and 51 respectively. So for the question number 1, answer A. Question number 2, which of the following is not necessarily false? Governor is not appointed by the Prime Minister. It's a true statement because governor is appointed by the President. Prime Minister is not elected by the Lok Sabha because he's the Prime Minister. He is leader of the House, appointed by the President. Governor seems to be more powerful than the President. D, in a state having bicameral legislature, the upper house has to approve the general bills within 6 months. So the state having a bicameral legislature, upper house has to approve the general bills within 3 months in the first journey, and in the second journey it should be done in the within 30 days. So the answer C is the question number 2 answer is C, because governor seems more powerful than the president when he is enjoying the discretionary powers. So 2 is C. 3, ordinance power of the governor is a legislative power, executive power, or a judicial power, or discretionary power. So issuing ordinance will be done by the governor only on the advice of the chief minister and the council of ministers, and it is a legislative power because the governor enjoys this power under Article 213, Article 213, because it will have the legislative power, will have the ordinance will have the same power as the law made by the state legislature. So answer 3A. The basic form of the union government envisaged in the constitution is a stable executive, 2. Responsible executive, impartial to all the religions, castes, and communities. So the fundamental form of government at the union and the state level is only parliamentary government. So it cannot guarantee the stable government, because particularly when there is a presidential government, you can guarantee the stable government. While this is, you know, since it is a parliamentary government, there is every possibility of unstable executive. So, responsible executive, impartial to religions, castes, as you see for the question number 4. Question number 5. Judicial review explicit in which of the following articles? Actually, explicitly, there is no judicial review. Only Article 13 is saying that it is an implicit power of the Supreme Court or the High Courts, because no law, any law enacted in violation of the fundamental rights can be declared void by the courts. But the term judicial review is not explicitly mentioned here. 32 is about right to constitutional remedies, and 226 is about the writ issuing power of the high courts. So there is no provision in the entire constitution. Hence, answer is D. 5D. The Supreme Court in the AP Civil Liberties Association case declared that it is illegal for the compulsory use of narco analysis, brain mapping, and polygraphy tests. And these are the tests that are used to make a convict to reveal the truth without using the third degree kind of methods. Brain mapping and polygraphy tests. Such techniques amount to cruel, degrading treatment and unwarranted intrusion into personal liberty. So such tests are violation of which of the following articles of the Constitution? Because Article 20 is saying that nobody can be forced to give evidence against himself. 21 is about right to life and liberty. 22 is again right against arrest and detention. Article 14 is right to equality before the law. So this question number 6 is asking in what way forcing a person to give evidence against himself is provided in the Article 20. That is answer A for question number 6. 7. Which of the following is correct according to the Constitution? India is a union of states and union territories. India is unitary. India is a federation. India is a quasi-federation. So B, C, D are wrong because India is not exclusively unitary nor exclusively federation. It is not even declared as a quasi-federation by the Constitution. So it is in the Article 1, it is declared as a union of states and union territories. 8. The original jurisdiction of... So question number 7, answer is A. Question number 8. The original jurisdiction of Supreme Court is related to resolving the federal disputes, appealing civil cases, judicial review, and all the above. So it is to resolve the federal disputes. So under the original jurisdiction means the meaning of original jurisdiction is you can directly appeal to the Supreme Court whenever there is a possibility of appealing. So usually in a civil case or a criminal case, people can appeal to the Supreme Court from the High Court. When a case is declared by the lower court, then it will be appealed to the higher court, and from higher court to the Supreme Court. So the federal disputes, that is disputes between central government and the state government and among the states, would be directly challenged in the Supreme Court only. So that is the original jurisdiction. So answer A for question number 8. How did the Indian Federation was formed? For the ninth question, Indian Federation was formed by integration or by disintegration. So Indian Federation is formed by disintegration, whereas American Federation was formed by the integration. 13 independent colonies were integrated into a federation, while Indian Federation was created by a disintegration. Disintegration stands for by dividing the unitary government into the states. The East India Company has established a unitary government in India. It is for the first time in 1935. The idea of federation was conceived. So, by disintegrating the unitary government into the states, the federal system is being created. So, therefore, answer is B for question number 9. And for question number 10, the federal concept was introduced for the first time by. So, as I told you now in the previous question, that the idea of federation was for the first time introduced by the 1935 Government of India Act. Till then, India was a unitary government. The 1935 Government of India Act has introduced the federal scheme for the first time with by creating the states. However, this federal scheme was not implemented. So it was not implemented because the Indians have not accepted the federal approach. The 1935 Government of India Act, because the Indians have not been incorporated into the in the preparation of this legislation. So the 1935 Government of India Act has conceived the federal approach, but however it was not implemented. The question for this question, the answer is 1935 Government of India Act. Question number 10, answer is B. Question number 11. Which of the following statements is incorrect? Constitution has been framed by the people of India. India was a unitary government converted into federation. Indian Federation is an American type. Indian Federation establishes dual government. So Constitution of India has been framed by the Constituent Assembly on behalf of the people, of course, but not directly by the people. By the people, on behalf of the people, the Constituent Assembly has made it. India was a unitary government converted into a federation. Indian Federation is an American type, but the actual answer should be it is a no, it is not American type. It is Canadian type. Indian Federation establishes dual government is also true. So the incorrect statement is only C, because instead of America, it should be Canada. Indian Federation, dual government at the center and states. Indian Constitution was framed by the people of India. On behalf of the people of India, it was made by the Constituent Assembly. So initially, it was a unitary government. By the 1935 Act, it was converted into a federalism. So 11 is C. Which of the following statement is not incorrect? So when we say not incorrect, it should be correct statement. In India, residuary powers rest with the states is wrong. Because in America, they are given to the states, while in India, they are given to the central government. Lok Sabha is not a representative of the states. Is a true statement, because Lok Sabha is representing the people, while Rajya Sabha representing the states. A separate body is required to amend the constitution is not correct, because the constitution is amended by the parliament only. Except Supreme Court, there is no other institution in India to protect the federal interest. It is also wrong, because apart from the Supreme Court, there are also other agencies like Rajya Sabha, Interstate Council, are also responsible for protecting the interests of the states. So answer is B. which is a correct statement, because the Lok Sabha is not a representative of the states. It is a representative because it's a representative of the people. So 12B. Find the correct statement. There is no equal representation for the states in the Rajya Sabha. Is true because every state has representation according to the proportion of their population. Rajya Sabha is completely an elected body. It is not true because it is partly elected and 12 members in the Rajya Sabha are nominated by the President. The Rajya Sabha can pass a resolution to enact a law on the state list in the interest of the states. So it should be in the national interest. Rajya Sabha enacting a legislation in the national interest, not the state interest. So instead of states, it should be national. D, there is representation to the union territories in the Rajya Sabha. So here, the answer should be both A and D. So the answer properly not given. There is no equal representation for the states in the Rajya Sabha is true. At the same time, there is representation to the union territories in the Rajya Sabha is also true. So you can choose either of the two. Both are correct. The combinations are not given in this question. Which of the following can perform functions commonly for both union and states? All India services, that is the IAS, IPS, and Indian Forest Service. Election Commission, which conducts the election for the Parliament, President, Vice President, as well as the state legislatures. C&AG, who audits the accounts of both central government as well as state governments. UPSC conducts the recruitment exams for the union government as well as on the request of the governor of any state. The union government can also, the UPSC can also conduct the recruitment for the states also. So all the four are correct. 14A. 15. Which of the following factors proves that Constitution has a unitary bias? Dependence on the state of the states over the union government for financial resources. Particularly after the GST enactment, it has become more. Planning was a concurrent power, even by the planning process also, because planning is incorporated, socio-economic planning. Planning for socio-economic development has been incorporated in the concurrent list. So when something is in the concurrent item, automatically it is more towards the central government. So both 1 and 2 are correct. Who said that India is a cooperative federation? It's a straight question, very commonly asked question. It is B, that is Granville Aston, 16B. And 17, what is meant by cooperative federation? Whether it is states depending upon the union or union depending upon the states, or mutual dependency of the union and government, state governments. Union and state governments are independent of each other. So when it is union and state governments are independent of each other, we call that as confederation. D as a confederation. C is a cooperative federation. Mutual dependency of the both union and states. So states depending on the union is a quasi-federal system. Then 18. Which of the following is a feature of Indian Constitution? Unitary feature of Indian Constitution. Supreme Court is a federal feature. Bicameralism. In the upper house, there will be a representative of the states. Where there is bicameralism, it's a federal feature. Division of powers between central and states is a federal feature. Emergency provisions. Union domination over the states. So it's a unitary feature. Flexible constitution. The flexible nature of the constitution makes it easy for the union government to amend the constitution where there is no participation of the states. Written constitution. A written constitution is required for a federation because a written constitution would be necessary to equally divide the powers between the central and state governments. And a unicameralism, which India is not having actually. Unicameralism is a feature of the unitary government, but in India there is no unicameralism because we have a bicameralism. So, according to the given provisions, given question, unitary feature of Indian Constitution, it should be only 4 and 5. So, D for question number 18. Which of the following is a federal feature? Single citizenship is a unitary feature. Unified services, that means the services which are common for both. Written constitution is required for a federation because a federal system will divide the powers in a written form between the central and state governments. Delegation of powers is existing in the unitary government. The central government will delegate some of its powers to the local bodies, not the states, in a unitary government. So, answer is written constitution for 19. 19C. So, delegation of powers is different. Delegation of powers is not existing in the federation. A federation will have a division of powers rather than delegation of powers. Delegation of powers will be a feature of the unitary government because in the unitary government you will have central government and the local bodies, something like England. In England there are no states, but there are local governments. So in the local governments there will be a delegation of powers from central to the local bodies. Given options, a written constitution is required for a federation. For a written division of powers between the central and states. 20. Which of the following are the measures taken to implement the provisions in the directive principles of state policy that state shall take steps to separate the judiciary from executive under Article 50. 1973 Criminal Procedure Code, establishment of the PRIs, appointing the collectors with the magisterial powers. So in India, before 1973, we have the district collector responsible for both executive magistrate, acting as an executive magistrate as well as judicial magistrate. So collector as an executive was enjoying both executive powers as well as judicial powers. After the enactment of Criminal Procedure Code in 1973, collector was just left with executive magistrate powers, and a new post of district judge was created who was responsible for trialing the criminal cases. So the 1973 Criminal Procedure Code has separated the judicial powers from the collector, and a separate judicial magistrate has been constituted. So answer is A for 20. And 21, which of the following are the reasons for reviewing center-state relations by appointing a second committee under the chairmanship of Justice Madan Mohan Poonchi in 2007-10? It is liberalization, because after the 1988 first commission on center-state relations, Sarkaria Commission has presented the report, which was appointed in 1983, submitted the report in 1988. So after 1988, in just a span of 3 years, in 1991, liberalization was introduced. So Sarkaria Commission has made several recommendations without considering the possible introduction of the liberalization by replacing the socialism. So in the wake of 20 years of liberalization, 15 years of liberalization, the new commission was constituted. Similarly, after 1991, Naxalism was expanding across various states. Coalition government started forming since 1990, 89-90, and a need for interconnection of the rivers, which may probably create or reduce the interstate river water disputes. So therefore, all the factors were responsible for the constitution of a second commission on interstate relations. These four factors have been mentioned in the terms of references. And 22, which of the following are the discretionary powers of the governor? Reserving the state bills for the approval of the president, which is done by the governor under 201. Ordering for the prosecution of the ministers, including the chief minister. Under the discretionary powers, it can happen. Sending a report to the president to impose the president rule in the state. Dissolving the state government and state legislature, also discretionary powers of the governor. So all the four are correct. So 22D is the answer. And 23, which of the following are the controversial issues in the center-state relations? The post of governor is anyway controversy. President rule is a controversy. All India services are controversial because they act as the union agencies, central government agencies working in the states. Similarly, central police forces may also be used by the central government to take over the powers of the states, particularly law and order related. So all the four issues are controversies. 23A. In 2004, the UPA government dismissed 4 governors appointed by the NDA government. The Supreme Court in 2010 censured the central government for this action in which of the following cases? So it was in the BP single case, in 2010. C is the answer for question number 24. And SR Bombay case has nothing to do because SR Bombay case happened in 1992-94. Nabab Rabia case has done with some different thing in 2016. In the Nabab Rabia case, the Supreme Court has for the first time reconstituted an abolished government by imposing the president rule. So in this context, 24C, in which of the following countries panchayats are found? Panchayats are not just the feature of India, they are also found in Pakistan as well as Nepal. So B is the answer for question number 25. And you also you can also find the panchayats even in Trinidad and Tobago. 26. Panchayats receives fund from which of the following sources? From all the sources. The major source of funding for the panchayats is grants in aid, and these are all the sources of panchayat revenues. 26D. 27. PISA Act 1996 is not applicable to Tamil Nadu. C. Remaining are in the 5th schedule states. The A, B, and D are the 5th schedule states. So therefore, it is not applicable to. It is applicable to the 5th schedule states, and it is not applicable to Tamil Nadu. C 27. 73rd Amendment is not applicable to Nagaland because the Constitution by itself, under Article 243 N, has exempted Nagaland and Mizoram, and Hyderabad and Delhi. They don't have the rural areas. So therefore, 73rd Amendment, which is applicable to the panchayat in the rural areas, 1, 2, 3, 4. So for all these areas, Nagaland, Hyderabad, Mizoram, and Delhi, they are they're not applicable. Provisions of 73rd Amendment are not applicable. 28A. So there is another question with the same question number 28. Which of the following are true about the Nyay Panchayats? Nyay Panchayats can be established at the level of every village panchayat. They are established as a forum. They handle both civil and criminal cases. Nyay Panchayat is a judicial panchayat. So they can handle the civil and criminal cases. And it is intended to implement Article 39A, which is guaranteeing a free legal aid to the poor people. So all the four is the correct answer. 29. Gram Sabha is responsible for passing resolution to the Gram Panchayats. Gram Sabha is a legislative body, so it passes a resolution to be implemented by the Gram Panchayat. Supervising the works undertaken under the NREGP. Looking after the implementation of the Forest Rights Act of 2006. This Forest Rights Act of 2006 will ensure the guarantee of land rights to the people living in tribal areas. So this land right transferability will be made by the Gram Sabha only, supervised by the Gram Sabha only. Answer is D for question number 29. 30. Identify the correct statement regarding the reservation in the local bodies as mandated by the 73-74th amendments. SC/ST reservation are in proportion to the population. Women reservation is 33%. BC reservation is not 27% because in the local bodies, BC reservation will be determined by the concerned state legislature by a law. So there is no fixed percentage of 27. So 1 and 2 is the answer for question number 30B. 31. Which of the following are not the recommendations of the Ashok Mehta Committee? Ashok Mehta Committee was appointed by the Janata government in 1977, which recommended a two-tier system of local bodies. And other recommendations includes active participation of the voluntary organization in the local activities, direct participation of the political parties in the local bodies. So you can see that in the after the 73rd Amendment, there is no direct participation of the local bodies. But it was recommended by the Ashok Mehta Committee. Nyay Panchayat should be kept within the developmental panchayats. It recommended to keep the Nyay Panchayats outside the general panchayats. Developmental panchayat means the routine panchayat raj institutions. And there should be a reservation of seats to the SC/STs was also recommended. It did not recommended C, 31C, because it recommended to keep the Nyay Panchayats outside the panchayat system. Then question number 32, which of the following implies constitutional status to the local bodies? The constitutional status ante ఏంటి? Local bodies ki periodical election to the local bodies will be guaranteed when there is a constitutional status. No superseding of the local body. Superseding of local bodies means abolishing a local body. Immediate election in case of premature dissolution. That is within 6 months, of course. Not waiting till the completion of 5 years. Guaranteed finances to the local bodies in the form of grants in aid and other things. So D is the answer, all the above. Which of the following are not the part of 12th schedule of the Constitution of India? 12th schedule is dealing with the powers and functions and finances of the urban local governments with 18 items. So it is dealing with the regulation of land use, planning, water supply, but not social forestry, but it is about the urban forestry. So 33 should be read as urban forestry instead of social forestry. You may not know that. 33D. 34. Urban local governments are managed by the Ministry of Union Urban Development, Ministry of Defense. So Ministry of Defense will also be responsible for managing the local governments. It will deal with the cantonments in the local governments. So answer 34 is both A. 34A. Supreme Court division bench can be established under Article 130 of the Constitution. 35A. Which of the following statements is not correct? Before that, the division bench of Supreme Court is like a branch of Supreme Court, where it is proposed that a Supreme Court branch can be constituted by the Chief Justice of Supreme Court by a communication given to the President. Of course, I'm sorry. It will be established by the President in consultation with the Chief Justice of Supreme Court. So, if the Supreme Court Chief Justice approves it, it can be established. Otherwise, if the Supreme Court Chief Justice has not given his positive reply, then the President cannot establish this. So there are proposals for a long time to establish the 4 division benches in the southern, northern, eastern, and western parts of the country, but which is not yet done. Which of the following statements is not correct? 36. Oath of the President is administered by the Chief Justice of Supreme Court. Correct statement. Each minister is individually responsible to the President. Is also correct. President cannot use his veto in case of bills other than general bills, because he can use the veto power only in case of the general bills, but not other bills like finance bills and money bills. So 36A. 37. Which of the following are the qualifications prescribed for the President? Citizenship of India is okay. Minimum age of 35 years is also okay. Membership in the Lok Sabha is not okay, because he should be qualified to be a member of Lok Sabha but not a member of Lok Sabha. And 4, should not engage in any office of profit is correct. So 37C, 1 to 4. Who elects the President? Members of Parliament, members of Lok Sabha, members of Rajya Sabha, members of Electoral College. 1, 2, 3, 4, 2, 3, 4, 3, 4, and 4 only. So it's just a logic question. Let's see who will answer this question. Who elects the President of India? Members of Parliament, members of Lok Sabha, members of Rajya Sabha, members of Electoral College. Is it all the above, or 2, 3, 4, or 3, 4, or 4 only? So answer for the question number 38 is D. Only 4. It should not be only the members of Parliament or members of Lok Sabha or Rajya Sabha only. Electoral College also consists of the elected members of Lok Sabha, Rajya Sabha, and the state legislative assemblies. So it should be only 4. D is the answer. What is Article 143? So it's an understanding based question. Should it be considered as a power of President, power of Governor, responsibility of the Supreme Court, or none of the above? Let me see who can answer this question. So it is the responsibility of the Supreme Court, not none of the above, because the President seeks the advice of the Supreme Court under Article 143, whereby the Supreme Court has the responsibility to give advice to the President. C. Which of the following is not applicable appointed by the President? CAG, Advocate General, Attorney General, or Solicitor General? So it's a simple question, a straightforward question. Question number 40 is Advocate General, because Advocate General is working at the state level. So appointed by the Governor. So question number 41. Which of the following is correct about the President legislative powers? President nominates 14 members. So let me see who will answer this question first. President nominates 12 eminent persons to the Lok Sabha. President appoints the Speaker of Lok Sabha. President has the power to adjourn the Parliament. So is anybody answering this question? 41. President nominating 14 members. President nominating 12 eminent persons to the Lok Sabha. President appointing the Speaker. President has the power to adjourn the Parliament. So answer is A. Oh, Vishwan Raj has answered this question. 41A, because uh, two Anglo-Indians are nominated to the Lok Sabha. Hereafter, it may not be there. And 12 eminent persons are nominated to the Rajya Sabha, not to the Lok Sabha. Then President will not appoint the Speaker. Speaker is elected from among the members of Lok Sabha. President will not adjourn the Parliament. No, the Lok Sabha shall be adjourned by the Speaker. Rajya Sabha shall be adjourned by the the chairman of the Rajya Sabha. Adjournment is a temporary postponement. So they are the powers of respective house chairpersons. 41A. President can pardon death punishment imposed by which of the following courts? Supreme Court, High Court, and the Court Martial, but not Supreme Court, High Court, Court Martial, as well as the District Court. So 43D. Which of the following are true about the election of the president? So as far as practicable, there shall be uniformity, and every elected member of the Legislative Assembly shall have as many votes as the number of. So it's a principle followed in implementing the election of the president. So both 1 and 2 is the answer for 44. 45. Which of the following powers of the president requires the approval of the president, the approval of the parliament? Now, when president makes something, decision, parliament has to approve it. When president declares war, declares emergency, and with reference to the international treaties also, that parliament has to approve. 45A. The nature of election of the president is president represents the nation because Lok Sabha is participating. He represents the people of different states because legislative assemblies are participating. The election recognizes the status of states in the federal system. So, because Rajya Sabha is participating. One is because, option 1 is correct because Lok Sabha members are participating. 2 is correct because assemblies are participating. 3 is correct because Rajya Sabha is participating. So 46A. Which of the following are true? In case of vacancy of post of president due to the death or resignation or removal or election of fill, the vacancy should be held within 14 days. So it's wrong because it should be within 6 months. In case of a vacancy of the post of vice president due to the death or resignation, to fill the vacancy should be held within 6 months of the occurrence of the vacancy is also wrong because there is no provision of 6 months. Because it is mentioning that as soon as the possible. So 2 is wrong. So answer D, neither is correct. 1 is wrong because it should be 6 months. 2 is wrong because at the earliest possible. Not within 6 months. At the earliest possible, it should be. So 47D. Then 48. So the following are the legislative powers of the president: dissolving the Lok Sabha, addressing the parliament, nominating 14 members to the parliament, presiding over a joint meeting. So president will do everything except presiding over a joint meeting. The joint meeting will be summoned by the president while presided over by the speaker of the Lok Sabha. Joint meeting is only summoned by the president. So 48 is B. And which of the following is a function of the parliament? Providing a cabinet, because cabinet will be formed from both the houses of parliament. Criticizing the cabinet, controlling the cabinet. So all the powers. 49D. Who frames the policies? It is not the law, but a policy. Law is enacted by the parliament. To implement the law, you need a policy. That policy will be formulated by the cabinet. Cabinet is considered as the biggest policy making body in the country. It is also the most powerful policy maker in the country. 51. Which of the following is the most powerful organ of information? Let me see who will answer this question. Most powerful organ of information. That means more authentically who can collect the information from the government. Whether it is press, parliament, public opinion, TV and radio. So anybody is answering. So the authentic information can be derived only by the parliament, nobody else. Because government cannot misdirect the parliament in giving the information. So 51B, parliament. So powerful organ, neither press nor TV, it is parliament. Public opinion is not an organ. Who coined the terms Lok Sabha and the Rajya Sabha? So the first speaker of Lok Sabha, G.V. Maulankar, who was the first speaker, coined these words to be catchy because in the constitution, Lok Sabha is termed everywhere in the constitution as House of People. Rajya Sabha is named as House of Council of States. So they are not easily understood by the people in general. So therefore, Maulankar have coined these words Lok Sabha and Rajya Sabha. 52B. President nominates from which of the following fields to the Lok Sabha? Arts, literature, science, social service, sports. Even from the sports field also, Tendulkar was nominated to the Rajya Sabha. So from President nominates to which of these following to the Lok Sabha? Let me see who is answering this question, a logical question. D, none of the above, because for all these fields, it is they are connected with the Rajya Sabha but not the Lok Sabha. Answer for 53 is D. 54. Rajya Sabha has power in which of the following aspects? The members of Rajya Sabha can ask the questions in the question hour. There is also a 0 hour. They can also discuss the budget, but they cannot vote on the budget. Nothing can prevent the Parliament from Rajya Sabha from discussing the budget, as mentioned in the Article 110 of the Constitution. So 54A, Rajya Sabha can discuss the budget but cannot vote. 55. How does the Union Territories elect the members to the Rajya Sabha? So they are elected by the Electoral College. They are elected by the legislature. They are elected by the people. Union Territories cannot participate in the election of the Rajya Sabha. So the 55A, because for the electoral, the special electoral college will be constituted for this purpose of electing the members of Rajya Sabha from the Union Territories. 56. Which of the following statements are not correct? Not correct. Not correct means they are wrong. Not more than 530 elected to the Lok Sabha from states is correct. Not more than 20 members are elected to the Lok Sabha from the Union Territories is also correct. There is no representation to any minorities in the Lok Sabha is wrong. The representatives from the Union Territories directly elected by the people in the Lok Sabha. So 56C is wrong because there are minorities who are represented in the Lok Sabha. Why proportional representation is not adopted for the House of People? Proportional representation is adopted for the election of the President, Vice President and the members of Rajya Sabha legislative councils, but not for the House of People, that is Lok Sabha. Because of the large scale illiteracy in the country, because when you adopt the proportional representation, you need to have a knowledge of reading and writing. But most of the people in India were not literate. Therefore, the British Royal Commission in 1910 has not recommended it. So, answer for 57 is D. Apart from this session of DPSP are established in part 3. Uh, 58. Parliament shall not consist of Council of States, House of People, titular head. So, who is answering this question? Let me see. 57, of course, D. I'm asking about the 58. Who will answer? Parliament shall not consist of what? Council of States means uh, Rajya Sabha. House of People means Lok Sabha. Titular head means the President of India. Titular head is the nominal head of the state, the President of India. So it consists of all the three. So answer is none of the above. It shall not consist of is the question. So answer should be D, none of the above. So for 58, D. And 59, who can prescribe additional qualification for the membership of the parliament? It is none other than the parliament itself. So the additional qualifications for the members of parliament have been mentioned in the 1951 Representation of Peoples Act. Article 102 has some qualifications, 84 has some qualifications. Additional qualifications were mentioned in the Representation of Peoples Act. So you need to read Article 84 with the Representation of Peoples Act for the qualification of the members of the parliament. And 102 has, Article 102 has disqualifications. 60. Which of the following is not a disqualification for membership of parliament? Unsound mind, sex, that is male or female, insolvency, a government employment. So is anybody answering this question? A simple question. Question number 60. Unsound mind is disqualified. Insolvency is disqualified. Government employment is disqualified. So answer is sex is not disqualified for 60. B is the answer. Both men and women are eligible. In which of the following elections members of the Lok Sabha participates? Election of the members of Lok Sabha participate in the election of president, being a member of electoral college. In the election of speaker, they elect also the deputy speaker. They elect the chairman of the Rajya Sabha and the pro tem speaker? Is the issue. B and D. So it's not B and D. It should be only B. 61 B, because there's no question of electing the pro tem speaker. Chairman of Rajya Sabha is the vice president. So since vice president is elected by both the members of Lok Sabha and the Rajya Sabha, being a part of the electoral college, so president, speaker, deputy speaker, and the chairman of Rajya Sabha, that means no, the vice president who is elected by both the members of Lok Sabha and the Rajya Sabha. So 61B. Then 62. Which of the following is not a function of the speaker? Presiding over a joint meeting, deciding a bill as a money bill or a general bill, casting a tie vote. Tie vote is when a bill is put for the voting. If there is equal number of votes supporting and opposing, then the speaker will cast the tiebreaker. Voting on demands for grants. Voting on demands for grants is the function of the Lok Sabha, but not the speaker. So 62D. Which voting on demands for grants and budget మీద ఓటేయడం. Which of the following, 63, is not an individual privilege of the members of Parliament? Freedom from arrest during the sessions of Parliament, freedom from attendance as witness in any court, freedom of speech on the floor of the House, a right to publish proceedings. 63 is D, because it is a collective privilege, not individual privilege. Because the question is asking you to identify which of the following is not a individual privilege. So ABC are the individual privileges. D is the collective privilege. Right to publish proceedings is the power that is enjoyed by the entire House as a whole. So far, how many joint meetings of the Parliament were held to approve a general bill? Oh. So far, 3 sessions, 3 times. That was the joint meetings have been held. 64C. For the first time, the last time when the joint meeting has held is in 2004 to approve the quota, and earlier it was held in 1961 to approve Anti-Dowry Act. Then again in 1977 to prohibit the Banking Service Commission Bill. So 1961, 1977, and 2004. 2002 to approve the quota. So 3 joint meetings were held. 65. If Rajya Sabha rejects a constitutional amendment bill, what will be the next consequence? Simple, the bill gets lapsed. 65A. Because President arranging joint meeting is possible only in the general bill. So there is no joint meeting in the case of once the Rajya Sabha has rejected a constitutional amendment bill, the bill gets lapsed. That's it. 65A. 66. Which of the following is a money bill under Article 110? So the 66 says that any bill certified as such by the Speaker is a money bill. That's it. So D is the answer. So a bill may be having the conditions as mentioned in the 1, 2, 3, but if the Speaker is not satisfied with these aspects, then the Speaker can declare a bill as a general bill. Even if this condition does not exist, this something like a Aadhaar bill in 2016. The Aadhaar bill was not fulfilling any one of these conditions, but still the Speaker has declared it as a money bill, and it's a money bill. It is unquestionable in the courts. So D is the answer under Article 110. Question number 67. Comptroller and Auditor General acts as a friend, philosopher, and guide to a straight question. The Public Accounts Committee. 67A. 68. Consider the following statement under Article 312 and identify the true statement. Rajya Sabha has to pass a resolution to create a new All India service. Parliament has to enact a law to create a new All India service. That is after the Rajya Sabha passing a resolution. That means only a resolution of the Rajya Sabha is not adequate. Parliament cannot enact a law unless resolution is passed by the Rajya Sabha to create a new All India service. So all the 4 statements are in consonance with each other. So 68 is A. If a new All India service has to be created, first Rajya Sabha has to pass a resolution. Second, Parliament has to enact a law. Parliament cannot enact a law without the resolution. A resolution will remain waste if the Parliament cannot enact a law. So these 2 things are mutually connected with each other. So therefore, all the above are correct. A is the answer. In which of the following matters the resolution of Rajya Sabha is required? Creating the new All India service, a resolution of Rajya Sabha is required. To make a law on state list in the national interest. In your question paper, you can make a correction. It should not be the state interest, it should be the national interest. So, based on the given question, the answer is only one. So, 69B. 70. Which of the following is not true? USA has a double court system, that is, a separate Supreme Court and state level high courts are different. So, high courts need not follow what Supreme Court says. In India, there is an integrated court system. Means every court in the country has to work under the hierarchy of the Supreme Court. See, at present, there is one high court for each state. Is wrong because there are only 24 high courts and some states with common high courts. Subordinate courts are controlled by the high courts. Is true. So C is not true. 70C. 71. Which of the following is the name of Panchayat courts? They may be called as the Nyay Panchayats, Panchayat Adalat, or Gram Kacheri. In some states like UP, they are called Gram Kacheris. So 71A. 72. Who determines the jurisdiction of the municipal courts? Parliament, Supreme Court, High Court, District Court. They are determined by the High Courts. 72. C. 73. Who is the highest judicial authority in the district? Highest judicial authority means the highest court of justice in the district level is district judge. A straight question, which is created, the district judge post, which is created by the 1973 Criminal Procedure Code. Till then, it was district collector. Till 1973, it was the district collector. But after 1973, it was the district judge. A is the answer. In which states judicial magistrates are trialing the criminal cases after the enactment of the Criminal Procedure Code? It is in both Jammu and Kashmir, Nagaland, Sikkim, as well as it is only 1 and 2. 74A. In which of the following metropolitan areas metropolitan magistrates are functioning? In Hyderabad, Hyderabad is a metropolitan area. Secunderabad also you have a metropolitan region, and in Kolkata also. So 75B. Metropolitan magistrate is a magistrate working in a metropolitan region. A metropolitan region is the one which is having a minimum population of 1 million. 76. Which is the common high court for Manipur, Meghalaya, and Tripura? None of the above, because 76D. In 2013, separate high courts have been established for all the three. Earlier, there was a common high court under the High Court of Guwahati. So D is the answer. Each of these states now have separate high courts of their own from 2013. 77. Who can decide the strength of the judges in the Supreme Court? A straight question. It is the Parliament by a law. Either can increase or reduce the number of judges in the Supreme Court, as happened in the recent times. The original number of judges in the Supreme Court, that was in 1950 when the Constitution of India has come into force, is 7 plus 1, that is B, 8. 78B. Who can appoint ad hoc judge of the Supreme Court? Ad hoc judge of the Supreme Court is appointed in case of inadequate quorum of the Supreme Court, as provided in the Article 127. So after consulting the Chief Justice of the concerned High Court, the Chief Justice will appoint the ad hoc judges of the Supreme Court. So answer is C for question number 79. 80. Which of the following is a qualification of Supreme Court judge? Oh, let me see who is answering this question. 80. Sana is saying B. 10 years experience as a High Court judge. 5 years experience as an advocate of Supreme Court. A minimum age of 65 years. and citizenship of India. So who is going to answer this? Let me see. I'm giving you a few more minutes, one more minute time to answer this question. Do you think that 10 years experience as a High Court judge is correct? So it's not correct because it should be 5 years experience as a judge of a High Court. 5 years experience as an advocate of Supreme Court. It should be 10 years experience as an advocate of Supreme Court. Advocate of High Court. 10 years experience as an advocate of High Court. There is no provision saying that there is a minimum 65 years of age. Right. And the only true statement, correct statement is citizenship of India. So D is the answer for question number 18. So you need to read the question properly before answering. You know the answer, but you are hurried in answering the question. So D, only 4 is correct. 1, 2, 3 statements are wrongly given. 81. A removal motion of Supreme Court judge is introduced with the signature of, with the notice of either 100 members of Lok Sabha or 50 members of Rajya Sabha. So should it be A or B or A and B? So 81 is either A or B. So C is the answer, not both required. If it is A and B, means notice to be given in both the Lok Sabha and Rajya Sabha. Notice is not required to be given in both the Lok Sabha and the Rajya Sabha. Notice is given only in one house, and it is approved in both the houses with 2/3 majority. So 81C, A or B, not A and B. Which of the following are exempted from original jurisdiction of Supreme Court? Interstate river water disputes, it is in the original jurisdiction. Matters referred to the Finance Commission. Interstate river water disputes, matters referred to the Finance Commission, treaty disputes. All the above have been exempted from original jurisdiction because first they have to go to a different agency. Interstate river water disputes first have to go to the River Water Disputes Tribunal. Matters referred to the Finance Commission are considered by the Finance Commission. Treaty disputes is under the International Court of Justice. So they are all exempted from the jurisdiction of the Supreme Court. 82D. And in which of the following matters President seeks the advice of Supreme Court on any question of law on a fact of public importance? So it is both 1 and 2. 83C. Which of the following are true? President, vice presidential election disputes can be questioned only in the Supreme Court. Disputes arising out of the election of the MP MLAs questioned only in the High Court first. So both are correct. In case of MP MLA disputes, election disputes, if you are defeated in the High Court, then you will appeal to the Supreme Court. So first appeal to the High Court only. 84A. 85. Under which of article Parliament can establish a common High Court for 2 or more states? C. 231. 85. Which of the following is not true about the appointment of the judges of High Court? Additional judges are appointed by the Chief Justice. Acting Chief Justice is appointed by the President. A retired judge can be appointed as the acting judge by the Chief Justice. Judges of the High Court shall be transferred by the President. So answer is A for this question because additional judges are appointed by the President, not the Chief Justice. So you make a note in the question paper. For question number option number A, it should be the President, not the Chief Justice. 86A. By heart these 4 statements. They may be given as the question. 87. A judge of a High Court may be removed by the President. A person shall not be disqualified to be appointed as a judge of a high court unless he has at least 10 years held a judicial office in the country. Uh, so, is anybody answering this question? A judge of a high court may be removed by the president, true or false? So, it's a true statement because the parliament will approve it for the removal and then the president will remove. So, therefore, there is nothing wrong. So, both the statements are correct. 87A. 88. By which amendment the retirement age of the High Court judge is increased from 60 years to 62 years? Originally, the retirement age was 60 years. It was increased to 62 years. Now, there is again a proposal to increase the retirement age from 62 years to 65 years. So, it's still a proposal, not being implemented. So, therefore, keeping that proposal in view, I have given this question. So, answer for this question is A, 15th Amendment in 1963. 88. A. 1963. 15th Amendment. 89. Which of the following is the method of vacating the office of High Court Judge? The High Court Judge office can be vacated by a resignation addressed to the governor, not the president, by being appointed as a judge of Supreme Court. So automatically there will be a vacancy in the High Court, or a transfer to another High Court. So all the three are correct. 89A. 90. Public interest litigation in India is accepted by the High Court under Article 226. Supreme Court aithe 32. High Court under Article 226, and remember that there is no explicit provision about the public interest litigation in the Constitution. No explicit provision, అంటే డైరెక్ట్ గా చెప్పలేదు సుప్రీం కోర్ట్ కాన్స్టిట్యూషన్ లో ఎక్కడ పబ్లిక్ ఇంట్రెస్ట్ లిటిగేషన్ గురించి చెప్పలేదు. బట్ 91. Whom does the governor consult in appointing the judges of subordinate courts? The subordinate courts are the district courts. So district courts judges are appointed by the governor in consultation with the High Court. 91A. Whom does the governor consults in appointing the persons other than the district judges to the judicial service of the state? Other than district judges at a district court lo unde registers, administrative offices belong. So registers, administrative staff, they're all appointed by the governor through a recruitment examination conducted by the State Public Service Commission and in consultation with the High Court. So 1 and 2 is the answer. 92B. Bharat Kumar has answered B. It's correct. 93. Administrative Tribunal Act was passed in the year 1985, but they were established in 1986. So 93A. There is also a proposal now for the abolition of these administrative tribunals and to replace with the new systems. So the act was made in 1985, actually established in 1986. Remember these two. 94. Any promotion of judicial service inferior to the district judge is done by the High Court. Promotions is done by the High Court Chief Justice. The island of Andaman Nicobar comes under the jurisdiction of which High Court? Andaman and Nicobar Islands comes under the jurisdiction of the High Court of Calcutta. That is D is the answer for 95. So it should not be called as the West Bengal High Court. It should be called only as the Calcutta High Court, because for in Tamil Nadu, Maharashtra and Calcutta, they are the earliest high courts established in the country, and the names of the concerned capitals have changed. The Madras has been changed as Chennai, Bombay changed as Mumbai, Calcutta is changed as Kolkata. But the names of high courts have not changed. They continue to be called as Calcutta High Court, Madras High Court, and Bombay High Court. So 95D. 96. Which of the following is the first High Court in the country? 96. Who is answering this question? Calcutta, Madras, Bombay, all are constituted at the same time. So they cannot be constituted at the same time. So the first High Court to August, Madras High Court on August 15th, 1862. Then Bombay High Court, 1862, August 14, August 14, 1862. So Calcutta is the answer, 96A. So there is no 1774 High Court. High Courts were established by a 1861 High Courts Indian High Courts Act. So accordingly, they have been constituted in the same year, but not at the same time. All the three have established in 1862 with a gap of a few days. That's all. So 96A, which of the following existed in the Constitution when the Constitution came into force? సో కాన్స్టిట్యూషన్ వచ్చినప్పుడు అమల్లోకి వచ్చినప్పుడు ఏమేమి ఉన్నాయి అంటే 1950లో ఉన్నాయండి. అంటే యూనియన్ గవర్నమెంట్ ఉంది, స్టేట్ గవర్నమెంట్స్ వర్ దేర్, యూనియన్ టెరిటరీస్ వర్ ఆల్సో దేర్, బట్ నాట్ ద లోకల్ గవర్నమెంట్స్. సో 1970. 98. Which of the following are not found in the Constitution explicitly? So explicitly అంటే ఆ వర్డ్స్ తోటో లేకపోతే వాటికి సంబంధించినటువంటి అంశాలతో ఒక ఆర్టికల్ ఉండడం. సో ఎక్స్ప్లిసిట్ గా లేవు అంటే ఇంప్లిసిట్ గా ఉంటుండొచ్చు. ఇంప్లిసిట్ గా అంటే బేస్డ్ ఆన్ ద ఇంటర్ప్రిటేషన్ ఆఫ్ ద ఇష్యూ యూ కెన్ సీ దట్ దేర్ మే బి. సాలిసిటర్ జనరల్ ఇస్ నాట్ ఎట్ ఆల్ దేర్. అటార్నీ జనరల్ ఉంది కానీ సాలిసిటర్ జనరల్ లేదు. పబ్లిక్ ఇంట్రెస్ట్ లిటిగేషన్ ఇంతకు ముందే చెప్పాను అసలు లేదని చెప్పి. బట్ సుప్రీంకోర్టు, హైకోర్టు, సుప్రీంకోర్టు ఆర్టికల్ 32లో, ఆర్టికల్ 226లో ఏమో హైకోర్టులు కేసులు తీసుకుంటాయి. బట్ పబ్లిక్ ఇంట్రెస్ట్ లిటిగేషన్ గురించి స్పెసిఫిక్ గా చెప్పలేదు. అండ్ జుడిషియల్ రివ్యూ గురించి కూడా స్పెసిఫిక్ గా ఎక్కడ చెప్పలేదు. ఆర్టికల్ 13లో ఏముంది? ఆర్టికల్ 13 is saying that any law contravening with the fundamental rights may be declared void by the courts అని మాత్రమే ఉంది తప్ప జుడిషియల్ రివ్యూ అని మాత్రం ఎక్కడ లేదు. కాబట్టి ఆన్సర్ టు 98 is A. 97 once again. సో 97 అంటే కాన్స్టిట్యూషన్ ఇంప్లిమెంటేషన్ లోకి వచ్చినప్పుడు ఏమున్నాయి? యూనియన్ గవర్నమెంట్ ఉంది, స్టేట్ గవర్నమెంట్ ఉంది, బట్ లోకల్ గవర్నమెంట్ 73, 74th అమెండ్మెంట్స్ ద్వారా వచ్చినాయి. కాబట్టి లోకల్ గవర్నమెంట్స్ లేవు, యూనియన్ టెరిటరీస్ ఉన్నాయి. సో 1, 2, 97, 1, 2 and 4. 97 is C. I'm sorry. 97 C answer. Thank you for reminding me. 99. Which of the following serving as the common high court? High Court of Hyderabad ఇప్పుడు లేదు. హైకోర్ట్ ఆఫ్ హైదరాబాద్ ఉన్నప్పుడు అంటే సెపరేట్ హైకోర్టు ఆంధ్రప్రదేశ్కి ఏర్పాటు చేసిన తర్వాత హైకోర్ట్ ఆఫ్ హైదరాబాద్ పేరు మార్చేశారు. ఇప్పుడు తెలంగాణ హైకోర్టు, ఆంధ్రప్రదేశ్ హైకోర్టు ఉంది. ఆఫ్టర్ ద సెపరేట్ డివిజన్ ఆఫ్ స్టేట్, bifurcation of state, in 2014 High Court of Hyderabad was constituted and which was serving both the states. High Court of Madras is common high court for Tamil Nadu, tarvata Pondicherry. Bombay High Court is common for Maharashtra as well as Goa. Calcutta High Court is common for both West Bengal as well as Andaman Nicobar Islands. So answer for 99 is B. 2, 3, 4. A decision of the governor may be discretionary, need not be based on the advice of the chief minister, and open for judicial review. So what is correct for question number 100? So is going to answer this last question. Let me see. Satya is saying all the above is correct, and the governor decision may be discretionary, and when it is discretionary, it need not be based on the advice of the chief minister, but it is still open for the judicial review. Hence, it is D correct. So, if you have any other doubts, please let me know before I close the session. I will just review. So next question paper I will post day after tomorrow. If you have any other questions, you can post me over the personally to my WhatsApp number. I'm ending the stream.